The next 15 or 20 minutes, I will very briefly highlight a few interesting topics you need to be aware of when investing in Belgium from a corporate legal perspective. I just called this 10 things to remember, but also obviously in the framework and taking into account the timing, I will spend some more time on some topics than on others. To be very honest, the first one, the reform of the Belgian Company Law, I think this is really a crucial one. Just to give you kind of the flavor and to give you the framework. So it was really the ambition of well, I would say the most famous corporate law professor, Koen, who in the meantime became the Belgian Minister of Justice, to really do this reform of Belgian corporate law to actually make Belgium the Delaware of Europe. So I'm just mentioning this as some background information, that was actually the true ambition to modernize and to really attract more businesses and to make Belgium corporate law easier to apply and to really attract companies not only from just Belgium, but really from all over the world. And I will still come back to this point. So the idea was really simplification. How has this been done? For example, by the abolition of several corporate legal entity forms. So there used to be, I think, even 14 different legal entity forms. Now it has been simplified to 4. Flexibility. There used to be a minimum capital requirement, and there actually the Belgium legislator has been inspired by the UK Limited to actually have companies without capital. So there's the capital requirement, which was really a fundamental element and characteristic of the BVBA, the private limited liability company, that has been abolished. And then thirdly, just to illustrate it, obviously also an adoption needed to be made to EU legislation. And I would say that the prime example is actually that Belgium now has also adopted the incorporation theory. Also only, and this is important to stress, and maybe Mark and we can have a chat in the Q&A on that topic, but for tax purposes, the real seat doctrine is still applied. But long story short, if a Belgian company now incorporates in Belgium, basically, and so the company has been incorporated in Belgium, even if the real seat would transfer towards another jurisdiction, to France, to the UK, it will always stay a Belgian company to which Belgian corporate law would be applicable. So this, I took some time on this topic, but just to give you the general framework and the true ambition of simplification and flexibility. Then the main topic, to be very honest, of the first breakout session is this topic. Rather, will you go for a BV or an NV? As said, there's now 4 main corporate forms. One is not with full legal personality. It's the partnership. Also a very interesting topic for Mark and I to discuss on, because this isn't transparent, the partnership. But then you have 3 types of full legal personality, and it's the BV, the NV, and the CV. The CV is the corporative type of company, and that's why it's not being discussed. But for everyone basically wanting and willing to do business in Belgium, you will see there is a choice between this limited liability company, the BV, or the public limited liability company. And that word public really explains what the main difference or the vision is behind it. It's truly for the larger, bigger companies. This does not mean that those companies, the NVs, are all listed companies. So there's definitely a distinction there. to get a flavor of some of the differences between those two types of company, let me just stress the first one is that it used to be that also the BV had a capital minimum requirement, and that has been abolished. So, long story short, this means that in order to incorporate, you can go in front of a public notary, which is very easy. It's one day, and Frederic Helsen from Berquin, who is giving the breakout session one, we're very well known to each other and used to work with each other. So this is really a swift process, the incorporation of a BV. Whereas if you go for the NV, it's also a swift incorporation process, but there you need at least still to have 61,500 euros fully paid up at the moment of incorporation. So that might definitely be a hurdle or a threshold that you must meet if you want to go for the BV, for the NV, my apologies. So this is just on the two different legal entity types. Then, and this has also been touched from a tax perspective by Mark, obviously. Do I need to go for a branch or a subsidiary? To be very honest, before the Belgian company code reform, I believe from a corporate laws perspective and a flexibility perspective, there were more arguments actually to set up a branch, maybe in some circumstances. But now, given you have the BV, given that the BV no longer has to have this minimum capital, which used to be 18,550 euros, from a corporate law perspective, I really don't see many benefits anymore to actually set up a branch. Also, obviously, taking into a perspective that a subsidiary such as the limited liability company, the BV, gives you, as the word says it itself, a limited liability. So NV, BV, branch, subsidiary, these are very interesting questions, but it has been simplified, and that's what we also see in practice, that most entrepreneurs, and when I say most, it's really a very high percentage, they go for the BV nowadays due to the reform. Obviously, this triggers another question. You could actually say, wait a minute, I want to become active in Belgium. Do I need to incorporate? Obviously, there is this the one other way which is we do all the time. It's private M&A. You could actually also go for the process of doing an acquisition in Belgium. It's a very important question, obviously, but if you want to keep it plain vanilla, easy and simple, and you say, okay, I want to incorporate such a BV, for example, what do I need to do? Very short, it's draft of a financial plan. You will need to be assisted by a financial, by an accountant, and then it's your bylaws you will draft. Then an important element, and basically the financial plan together with the block bank account, that are the two main elements to keep in mind, because if you want to still pay up some kind of cash contribution into a company, following the custom of the capital requirement that used to exist, we also still see that people, for example, pay up 2,500, 4,000 euros, because obviously the company needs to be able to operate as from its existence. So it's really a plain vanilla step-by-step approach, which can be done in a day. It goes very smoothly, obviously provided that your financial plan and your bank is set up in that respect as well. I'm just giving you all the steps for the incorporation, that you have it as a guideline and for your background information, but I'm not gonna just go through each and every step of it. As said, you have the incorporation. You could also opt for private M&A, and here it is important to realize there are some substantial differences in M&A practice between a UK practice and a Belgian practice. So if you're really considering doing M&A, what we see, and we very often worked for UK entrepreneurs, for UK companies doing acquisitions in Belgium, or we work hand in hand with UK law firms needing assistance in Belgium, for example. Here it is important to really know what is, let's say, market practice and standard in Belgium. One of the main topics, and I'm sure a few of in the audience are very familiar with it, but is in Belgium, when doing an acquisition, the principle of data room disclosure, for example, in your share purchase agreement, in your SPA, is very, very common, whereas in the UK, it's still a disclosure letter type of disclosure, which is the standard market practice there. So there's a few things really to keep in mind that are different between UK and Belgian M&A, if you want. Then, because they also asked me to briefly really touch upon the legal compliance, it's once you have incorporated in Belgium, obviously, how will the world, so to say, know that you have been incorporated? And in Belgium, it's called the Belgium Official Gazette. So it's nowadays an online, it used to be in paper, but now it's all fully online. It's every day, you can't even imagine. There's so many different decisions by each and every company that are daily being published. So to give you a very simple and easy example, if you incorporate, that will be published. But if then, for example, you want to change, appoint new directors, you have a director resigning, it is in that Belgium Official Gazette that all these decisions appear on a daily basis, and which are publishable and to be consulted for free by everyone in the entire world. It is indeed important when you think about your governance that you do that, because in terms of, for example, director's liability, in terms of who is actually authorized to bind the company, the directors listed and published in the Belgium Official Gazette, that are for third parties, the true directors. So it's really very important, and that's what is said here in the second bullet, that in order to be opposable towards third parties, you need those decisions being published. Very short, the Crossroad Bank for Enterprises, it's our local trade register. It's being linked with that Belgium Official Gazette, and it's what is in the UK known, it's basically the Belgium equivalent of the House of Companies extract. UBO registration, this is really for completeness sake. I trust that everyone is very familiar with this. And I'm just jumping right ahead to the statutory auditor. Statutory auditor, indeed, they do not always need to be appointed. Only as from certain thresholds being met, as you can see on the slide, you need to appoint a statutory auditor. The statutory auditor, if you will become an active company, in the sense that, for example, if you have at one point you want to do a cash contribution, but not only a cash contribution, but also, for example, a contribution in kind, the statutory auditor will need to draft a special report. So at different stages, when there are different corporate restructurings and steps involved, you really will not only need your statutory auditor with respect to the books and the annual accounts, but you will often see that the statutory auditor will need to work hand in hand with the management body, which is in Belgium typically a board of directors. So a statutory auditor, always a mandatory mandate of 3 years, which very often after an acquisition also can lead to discussions, but that's maybe also something else for the Q&A. When talking about annual compliance, annual corporate housekeeping, you must at least briefly mention the annual accounts, something which most people amongst you will be familiar with. The general rule for your background information is that within six months as of the closure of the financial year, your annual accounts need to be approved, and ultimately 7 months after the closure of the financial year, they will need to be filed with the National Bank of Belgium. So it's quite important for you to realize that it's just a link. It's nbb.be, and there you can find for everyone to see all the annual accounts of all companies active in Belgium, which is obviously very interesting for third parties when doing business, and it shows confidence. So just to give you that as well for your information. There's different kinds of types of annual accounts depending obviously on the size and the magnitude of your company. As you can see, the last here, if you do not meet more than 10 full-time equivalents and have these turnover and balance totals, you will only have to file a micro, so really a very short form type of annual accounts, instead of the large macro filing for the big companies. Annual report, also very interesting, goes hand in hand with the annual accounts. It's not mandatory for each and every company. Again, you will see those thresholds popping up again, but if you do it, it needs to contain information, especially during COVID. This was very, very relevant. Also following Brexit, this was very, very relevant because you will need, for example, describe the important events that have occurred after the end of the financial year in your annual report. And last but not least, and maybe a few words still here, it's on dividend distributions. There's in Belgium corporate law, once you have made a profit, it has become clear, so to say, thanks to the approval of your annual accounts. In most instances, you have different type of dividends, how they can be distributed. This distribution has been changed. The rules has been changed by this Belgian company reform. There is a difference between the NV type of company and the BV type of company. Why has this change, or how has this change been triggered? It's mostly linked to the fact that for the BV, the minimum capital requirement has been abolished. And so the old criterion that existed and that was linked also for the BVBA, the old version of the BV, to the capital has been abolished. So a few differences needed to be made. They say in practice that in the NV it's easier because there's only one test, the solvency test. But there's a whole debate now in Belgium legal doctrine whether or not, although it's not explicitly referred to for the NV, that also this last slide basically, that also the liquidity test need to be observed within the NV. So in all fairness, for directors, when declaring a dividend, also in the NV, it's something to keep in mind to actually do some type of liquidity test, although it's explicitly not referred to in the law. This was very, very briefly, in a nutshell, a few interesting topics, starting over the incorporation or the private M&A path, so to say, and then ending, when all goes well, obviously, with a dividend distribution, just to give you a flavor of the Belgium corporate legal framework in this respect. Thank you.